Actually, the present leadership had decided that first of all, we will put our house in order. For that purpose, when they received a direction from the Honorable Supreme Court to proceed against Mr. former Lieutenant General Faiz Hameed, they decided to proceed ahead because it was a complaint which was launched before Supreme Court and it was viewed by in the entire world because it was a live streaming going on in Supreme Court, and in that, Justice Honorable Chief Justice then Faiz Isa gave a direction in a written form to the Sanctity Ministry of Defense that you proceed against this person if there is an evidence against him. So thereafter, the competent decided this thing that it is a good example. We must start it. It is a great decision taken by the present army chief because it was not expected. Because Faiz Hameed, whatever he was doing, he was of the view that nobody can touch him because people had a fear and apprehension that he had files of everyone. Nobody would touch him because he would play havoc with them. But I personally feel it was General Asim Munir or Field Marshal Asim Munir realized this thing. It was a decision of his firmness that whosoever is the one against whom the complaint had received, we would proceed ahead. So he ordered in court of inquiry. So in the court of inquiry, in the army procedure is this: whenever you receive any complaint against any member of the armed forces, first of all, court of inquiry is to be ordered. Now, court of inquiry collects the evidence, and after collection of the evidence, they give their findings and recommendations. Now, in the court of inquiry, they gave a recommendation that there's a lot of evidence against him, and he has tarnished the image of armed forces in the eyes of a common man. People never expected this thing that one of the DGISI, the spy master, can play havoc with their own citizens. How they plundered the house of Mr. Moiz and what happened with him. He narrated the entire story in the live streaming of the Supreme Court proceeding. So after inquiry, it was recommended that action should be taken against him. So in the army, after court inquiry, then there is another forum that is known as recording of summary of evidence. It is in the army, some recording of summary of evidence is considered as a very sacred duty because in that matter, all the evidence is being recorded on oath. Every witness comes and he narrates his story on oath in the presence of the accused. And accused had a right to cross-examine him. And after recording of the summary of evidence, then the accused is being asked that if you are ready to make any statement. So he made a statement over there. And naturally, his statement was to some extent a confession that all these things, those have been recovered from him, all those involvement, to some extent he was privy to it, he knew it. He said, I had never expected that it would happen. He never thought that in Pakistan, in this third world country, where the spy master is the main pillar of the establishment, can be questioned and can be asked and can be tried. So in summary of evidence, when the evidence was collected, then the officer who records the summary of evidence, it is duty to frame the charges in the eyes of or in the light of evidence which had been collected. So he framed the charges. So then the procedure is charges were placed before the competent authority, and then the competent authority decides that these are the charges and this is the evidence which commensurate with the charges, and this man is required to be tried under Army Act. So thereafter he constitutes the court and charge sheet is being given to him, and thereafter the trial commences. And actually under the Army Act, every accused has a right to prepare his defense. He had a right to engage his own counsel. So free access was given to him to meet his team of counsels. They represented him. There is another story which I wanted to highlight here for the viewers. During Faiz Hameed's time, when Faiz Hameed was DGISI and Imran Khan was the Prime Minister and General Javed Bajwa was the Army Chief, during that time, 29 civilians were abducted and they were tried under the Secret Acts. We protested that, and I challenged all those convictions in Supreme Court. And then Justice Umar Ata Bandial was the Chief Justice. He never issued notice to Imran Khan. He never wanted to issue it. I put the whole record before them. We never wanted, being a lawyer and being an advocate, I am of the opinion that civilians should be tried by the civil court, not by the army. We tried to convince Khan Sahab also that this is a wrong practice which you are going to start. It must be stopped. Earlier, when the trials of civilians were convened, or they were being tried, special amendment was made in the Constitution, the 19th Amendment, under which the army was empowered to conduct the trial of the terrorists, the people, those who have a link with the terrorism. But now there is no amendment. That amendment has passed away. But why you are allowing this thing that these should be? But he was not ready to listen because he was at that time on one page. This one page mantra was going on. Whatsoever was doing Faiz Hameed, the Prime Minister has the concurrence, and same was General Bajwa Sahab. And those 29 people, we challenged it, and out of them, 3 were given death penalty. But Alhamdulillah, we took the case before Supreme Court. When Supreme Court did not took notice of it, then we brought those cases before the High Court, and naturally that execution had stopped. But the cases are still pending in the High Court. So it is a makafat amal, you can say, whatsoever they did, that has happened with them. Because actually one must remember this thing. Now in the Constitution, there is another article which has been introduced that is known as Article 10A, which guarantees right of fair trial and due process of law. Any trial can be challenged before any High Court or Supreme Court where that article is being ignored or disrespected. So Army was well aware of this fact that this case can be challenged in the High Court or Supreme Court on only this ground that trial was not fair or due process was not carried out. So Army was of mindful because of a reason they allowed him that you can have the counsel of your own choice. Normally people, one odd counsel is there, but he had a complete team of counsels. They were given full liberty to cross-examine the witnesses, to view the document record which was produced against him. And after cross-examination, they were never being asked by the president or any member of the court that you stop this cross-examining, and it is too lengthy. That's why it took 15 months. They gave them full liberty and everything came on record. And thereafter, the court found him guilty. So because they knew this thing that later on it can be challenged on this only sole ground that we were not being given because of a counsel or the fair trial was not there. As I discussed earlier, the 29 trials of civilians, those civilians were never being allowed to engage a counsel of their own choice. This is another on record which is available on the net. You can find the news because we have created a lot of raise hue and cry on those trials, that why these trials are going on where the even counsel were not being given. Their parents, family members came to know at the end of the trial that they have been convicted and they have been sentenced. So Army knew this thing, that this hue and cry would come again. So that's why they decided him that you can have the counsel of your own choice. Even he was given a right to bring his own witnesses in his defense. For that purpose, General Faiz Hameed, former General Faiz Hameed, asked this thing that he nominated a retired officer that he should be available to him so that focal person should meet his witnesses and he should arrange his meeting with them so that they should appear for his defense. And for that matter, even his family was allowed to meet with him. And this direction was given them that if they wanted to bring any defense witness, he will welcome. The army will facilitate them. You just bring them because it is your duty. Prosecution witness is the responsibility of state, and defense witness is the responsibility of the accused. You bring the witnesses, tell us, we will facilitate him, you can meet him, and only unfortunately, only 3 witnesses appeared in his defense, and even their position was not in his favor. He was not satisfied whatsoever they deposed against him because those witnesses, when they were cross-examined and they asked about their conduct, the past conduct of the former general, they were also not happy. Because of this reason, after 3 witnesses, he decided to drop remaining witnesses. He said, I don't require any other witness to come over. Because the witnesses appeared before the court, they had already given statements in the summary of evidence, and the entire summary of evidence was available with the defense witnesses. Now, defense counsels also. Now, it is the duty of defense counsels to find out any discrepancy in the statement of witness which he has deposed in the summary of evidence. And later on, if he is deposing anything other in the trial, he can be caught over there. And naturally, they have to assess it because it is the only cross-examination. Because of the test, you can check the veracity of the witnesses. Now their statements were already there. The defense counsel was there to cross-examine them. They were cross-examined. Everything was available there and everything is on record. And this record will be available to them before the Court of Appeal also, when they will challenge the matter before the Army Court of Appeal. That is the procedure. That is the fairness, I personally feel. If anything is unfair, they can brought in the knowledge of in the Army Court of Appeal, because yet the process has not been completed. The first stage has been completed where he has been convicted. The now second stage, appeal stage, is also continuous of the trial, where again the entire proceeding will be placed. Defense counsel would be available, and definitely they will bring, if any discrepancy is there, that this witness was tutored, or this witness said this thing in the summary of evidence, and later on he added something, or he padded something. So that is the beauty, or that is the art of the cross-examination. And then if they bring any discrepancy, naturally, then there will be dent in the prosecution case. If they could not, or they fail to bring any dent or any discrepancy, then naturally the prosecution wins the case. And that is the way the case is going to be discussed before the Army Court of Appeal. Thereafter, the Court of Appeal will also be announced, and its outcome or verdict will be announced in the public. Actually, appeal is going to be filed within 40 days. He is not no more general now, he is ex-general, because he is being dismissed from service, because he has been convicted, and after conviction you cannot write a rank. Then you are ex. Now that ex-general had a right, naturally he would discuss this thing with his counsels. They will prepare his case. And in army, there is another very good thing, that when trial concludes, they give him the paper that is known as format of appeal. That format of appeal contains the particular of the convict. At the same time, it contains all the charges, and then conviction and the sentence. Now, this page is known as the format of appeal. Now, along with this format of appeal, their defense counsel will put up the grounds of appeal, that these are the grounds. They will prepare the grounds. That's why the 40 days have been given to them, so that they should prepare the grounds and whatsoever discrepancy they have noted down during the trial, because during the trial they had at liberty to record the evidence. They took the notes of the evidence. They had complete record with them. Then they will apply to the military authorities. They will give access to them to the trial proceeding. Now, after getting access, they will prepare his defense and put up an appeal before the Army Court of Appeals. And thereafter, the Army Court of Appeal will announce the date of hearing. And again, the hearing would start. It will not be a lengthy process in the Army Court of Appeal, because generally Army Court of Appeal doesn't require to record evidence. If any evidence is deficient, which could not come at record due to some reason, some witness was abroad, he could not be called, so then they can make a request to the Army Court. And if Army Court of Appeal considered that some additional evidence is required, only then the additional evidence can be recorded. Otherwise, whatsoever is record prepared before the FGCM, Field General Court Martial, same is the record which is presented before the Army Court of Appeals, and the arguments are delivered on the basis of that evidence, and thereafter they give the decision. Whether they are going to maintain the decision of FGCM, they can reduce the sentence, they can enhance the sentence, they can dismiss the appeal. They have all the powers. The court is competent in all the manners. There were many examples. I myself appeared before the Army Court of Appeals, before the Air Force and Navy Court of Appeals also. In certain cases, they accepted our appeal and sentence was released, or sentence was reduced, or the individual was released. And there is an example also where sentence was increased also. This is also a practice in the army. I don't think so, because this is not a case of only secret act. This is the case of misuse of authority, where one of a citizen of Pakistan leveled serious allegations and he brought evidence. He himself was a victim. He appeared before the FGCM, and naturally he brought all the evidence before the FGCM, that how his family was treated, how they were being plundered. So all this evidence is there. It is to some extent, that person is also very important, who is a aggrieved person by this case, who launched a complaint, who had a courage to launch a complaint. Now it is in these circumstances, it is not possible for the CDF, though the CDF had the powers to remit the sentence. But generally in these cases, normally the practice in the army is CDS or Chief of Army Staff keeps on remitting the sentences only when the cases are pertaining to departmental offenses. The service offenses, if some service offense is there, then the practice is the normal remaining RI is remitted. It is not a service offense at all. It is an offense in which one common citizen has come before the August Supreme Court. Supreme Court directed them to proceed against them. And otherwise, it was a very serious case of, to some extent, it amounts to even dacoity. How he took, though, army under the Army Act, because by that time, this Faiz Hameed was retired from the army. He came in the catch of the army because of one reason, because law was already amended, under which after retirement for 5 years, he was supposed to have a cool period. He was not supposed to enter into the politics, because of which he was arrested. Now, Secret Act, anytime anyone can be arrested. He may be a civilian who violates the Secret Act if he shares any secret or he contains any secret with him which he was not supposed to keep. He was the custodian of the secret information, the secret operation plans of the army, being a chief spy master. And instead of handing it over at the time of retirement, he kept it with them. Naturally, he had no right at all to keep it, and those were recovered from him. And even the people to whom he asked that it should be transferred in my data record, they also appeared before the court, in which they on oath said that he directed us to transfer it in his data form. So they brought it. This is a very serious offense. He must have known it, that he was not supposed to keep any material pertaining to defense of Pakistan on his personal laptop. He may be in service at that time, because law says you cannot take these classified secret information even to your residence. Now, when you are retiring, you have given a certificate that I'm not having anything. How can you hold such a sensitive information in your personal laptop, which was recovered from him and brought before the court? So in such a nature, where one citizen of Pakistan has launched a very serious complaint against him, then I don't think so. It is not expected that any competent authority can pardon him in such a situation. I don't think so, because it would be a mockery then. If you pardon him, then what is the fate of the other people? Why the other people they are not the sons of lesser God, that they are lying in the loitering in the jails. And one man who had all the privilege and perks, and he was supposed to be the guardian of the state, and he did all this thing, and he is being pardoned, then it is just a mockery. Then people will not believe in the system, I personally feel. I am sure that the firmness with which this trial was conducted, that firmness demands, and it is expected, that he will never be let off. I tell you one thing, because it was a very difficult decision taken by the CDF to commence his trial, because it never happened earlier. Even in entire region, it never happened earlier that one of the spy master, who is the major pillar of the establishment, he is being arrested, interrogated, and ultimately tried. Such a heinous offenses. So I think it was the firmness of the army chief in which he decided this thing, that we must put our house in order, that in future nobody should play with the fate of this nation or with the common man. I think it is a great lesson, and it is a great message which has gone to the forces and other people also, that anyone who commits such a offense which comes in the purview of the anti-state activity, he cannot be spared at all. And much have been said by the DGISPR. I don't think there is any room for the pardon or remission or anything. Yes, it is the Court of Appeal. Court of Appeal has the ample powers. If they feel or if they see that there's some offenses lacking the evidence, some charges lacking the evidence, they had the legal option and they can reduce the sentence. It is up to them after going through evaluating the evidence which would be placed before them. Nobody else can reduce it. Court has the ample power. Court can give a decision. Naturally, court is also under oath. Court is not like that somebody has been called and made the president of the FGCM, because it is the members, the president Court of Appeal, then he had two members, and third member is from JAG's department, some senior officer. They would be evaluating the evidence and they will give the decision, and they are the competent authority so far as law is concerned and so far as offense is concerned. Actually, in army, in such type of offenses, rigorous imprisonment also being imposed. In civil, it is known as kaide ba mushakkat, that whenever you are in the custody, they will give you some task to do something. And normally the general laborers, the prisoners also do some labor in the courts, but naturally he is a general officer. And again, in the jail manual, anyone who is being placed in the jail or prison, as per his status, he is to be treated. What was his status? What was his education? Accordingly, by this they may give him some task to do it, but it doesn't mean that he's going to do any labor work over there, because it is a status again, as per the status, he will get the class in the jail. Normally, the general officers get a class in the jail in which they have a choice of their own food. They rest everything is as per the jail manual. And rigorous imprisonment doesn't mean, which is normally known as the rigorous imprisonment is the common persons, as they do labor in the jail or prisons. He is not going to do labor. Whenever you are in a class A prisoner or convict, then this type of rigorous imprisonment is just only on the papers, not on any matter or any ground. Actually, when this evidence was being collected against Faiz Hameed, at that time, lot of evidence has come in. Because of this reason that he was maintaining links with the political figures, with one particular political party, and as per the law, he was not supposed to interfere in the political matters, being DGISI for 5 years after retirement. It was an embargo on him. He violated that embargo. Because of this reason, his calls were picked up, his links were established, and thereafter he was arrested. So a lot of material has come in. But at that time, because direction of Supreme Court was there pertaining to the case of Moiz Khan, and during which the Secret Act was also attracted, so the military authorities decided this thing, that we will remain in the same parameters which has been laid down for us by the Supreme Court. We will not go right and left, because if they decided that if we will go ahead, normally in general people are not knowing this thing, that FGCM is a court which is created or constituted for trial of certain offences. Those have been already mentioned in the convening order, that FGCM cannot go beyond those sections and those charges. Those have been recorded in the convening authority or in the convening order. So in the convening order, all these charges were there. Those were being pointed out by the Honorable Supreme Court. So FGCM or Field General Court Martial was bound to give evidence, give verdict on the same charges on the basis of the evidence. They cannot go beyond. So at that time, it was decided by the military authorities. But if we add many other things, then this trial was not going to end up for another 1 year. So they decided, first of all, we should complete and we should honor the order of Supreme Court, and accordingly we should conclude the trial under the charges which have been pointed out by the Supreme Court, and other offences those have come up during the investigation, and we would restrict ourselves pertaining to these charges. And if any later stage, if evidence is revalued or any other evidence comes in front of them which attracts the provisions of Section 31 of the Army Act, which says creating dissatisfaction among the armed forces, preparing the people, instigating the people against the command, if any such evidence comes up, then naturally that evidence will be also placed before the competent authority, and then competent authority is empowered to constitute another FGCM to conduct the trial. If any civilian is involved in instigating the armed forces or the member of armed forces, then naturally at that time Faiz Hameed was in the army. If anyone finds or any evidence comes that he has been also asked or expected anything to do against the command, naturally that person would be also tried by the Army Act. These are the provisions. Because the very famous case is there, Brigadier FBLE case. Brigadier FBLE was retired brigadier. He was civilian at that point of time when he was arrested. And the charge against him was the same charges, that they were instigating the people, they were collecting the people, and again the trial was conducted against him. So at any time, because this is the offense section 21D, that any civilian who instigate the military persons or create dissatisfaction in the command, he can be tried under the Army Act. And naturally, they are evaluating the evidence. They have enough evidence which they have collected during those 15 months. But it depends on the competent authority. If they consider this evidence attracts the provisions of Section 31, then naturally anyone who being attracted by that law would be tried under the Army Act. There is no embargo that no second trial can be conducted. Second trial cannot be conducted on the same charges. These charges are over now. But any other charge or any other offense which is being highlighted or evidence available, the army is at liberty to conduct that trial also. Because one thing we must remember, this thing is very important factor. If there are 4 accused persons before the court, and out of those 4 persons, one person tries to become a witness, a wada approver, he wanted to make a statement against other 3 persons. So as per the Army Act, he cannot appear in the court till the time his case is being disposed of. Because if his case is not being disposed of, that he cannot become approver, because then it is a fear that he has been given promise or he has been given a threat that if you will become approver, you will be released, and if you will not become approver, you will be condemned. So in this case, now Faiz Hameed is a fit person to become approver because he has been condemned, he has been sentenced, now he is at liberty. Now nobody can threaten him or nobody can please him, because now he has been convicted person. Under the Army Act, any convicted person can become witness against any other person. He can become approver. In that case, he would not be tried in that case, but against whom he appears, he would be tried for that purpose. This is the law. It is a very clear law, because if Faiz Hameed would have not been convicted, then he would have not become approver. Law doesn't allow this thing. But his chapter has been closed. Now he is a separate status, being a convict. He can give a statement in writing that I have some evidence, I wanted to bring it before the court of law. The evidence will be evaluated by the military authorities, and after that they will record another evidence, summary of evidence, and thereafter the trial would commence. Very simple phenomena. No, this is not the question of rivalries. Actually, his conduct throughout the era, because naturally when he was acting as DGC, whatsoever he was doing, it was in the knowledge of everyone. You must remember this thing. First of all, Absar Alam Sahab was the person who wrote an article on this, that what Faiz Hameed is doing there in that area. Later on, he also received a bullet. This Absar Alam Sahab, very famous journalist and very famous, everyone knew this thing. Now, because at that time, this Asim Munir Sahab was not in a capacity to take any action against him. But naturally, when the things came from the Supreme Court side, then they decided to take the action accordingly. But he was a threat. He was a threat to system because of a reason. When he was the Lieutenant General, he used to visit in his area, and there used to be gatherings. And in those gatherings, people used to raise slogans, Chief of Army Staff, Faiz Hameed Zindabad. He never objected to it that I am Lieutenant General, I am not Chief of Army Staff. He was living in same illusions that he is the Chief of Army Staff. Because reason was simple. Because Imran Khan Sahab has announced it, one of the video recording, which is available on the net. He said that Faiz Hameed is our asset. We wanted to make him the army chief. Same was the view of General Qamar Bajwa. So man was thinking to become army chief. But naturally, the political leadership realized this thing. Whatsoever was the conduct of Faiz Hameed in the past, they knew, though he tried to have a liaison with them also. Whenever he comes to know that any MNA of Muslim League Noon is going to be arrested, he used to convey him that, okay, come here, I will give you a safe passage from so-and-so airport, you can go abroad, because I received order that you should be arrested, but I let you know. Because he was playing on both sides of the wicket. He was trying to maintain a balance, but they knew his worth, so they were not believing it. So it was understood that he had no chance, because who met Justice Shaukat Aziz Siddiqui, and he said, we will not make you a Chief Justice, because in that case, our 2 years' effort will be wasted. This is a statement given by the Honorable Justice Shaukat Aziz Siddiqui, very reliable person. He gave a statement and lost the job. He was sent home because of this statement which he gave in Rawalpindi Bar in the gatherings of hundreds of the lawyers, which was never being refuted by anybody. And this was the reason they knew this thing, that this man would play hell with the everything, because everyone knows it. And he was really a terror, because he can close any TV channel, he can close any circulation of any newspaper. Even newspapers like News and the Dawn were not allowed to be distributed in the Kent area or in the Askari colonies. You can well imagine how he was running this country. This was the reason he was having interference in every matter. It's not the rivalry of one person. He was playing with the fate of the whole institution. Because if he would have become this person with this much character, if he would have become the army chief, what would be the fate of this country? Then you can well imagine. So there is no question of rivalry, because I personally feel when the matter came from Supreme Court, then there was no option left over with the army chief to put his house in order. He decided that, okay, let's proceed ahead. And he went ahead accordingly. I think it was his great decision in which he showed his firmness and fairness. He gave him a complete right of defense. He said any witness, any counsel he wanted to bring, let him bring. If he wanted to bring witnesses defense, he is allowed to bring witnesses. Court was given open check that you proceed strictly as per the law, because this question should not come up later on that Article 10A has been violated by the Field General Court Martial. That's why it took 15 months to conclude the trial.